This program is brought to you by Emory University.
I'm Jennifer Murphy-Romig, a legal writing professor at Emory Law School and founder of Listen Like a Lawyer, a blog focusing on listening skills. Today I'm grateful to have Paul Zwier here. Paul is professor of law at Emory Law School, director of Emory's Advocacy Skills Program, and a sought-after teacher and leader of programming at the National Institute of Trial Advocacy, or NITA. Paul is also a co-author of the book Fact Investigation, Interviewing, Case Analysis, and Counseling for Effective Representation. This is a fantastic book about fact investigation, methods, theory, and it's really very useful. And today we're going to be exploring some of the ideas in that book specifically focused on listening. Paul, thanks for being here.
Glad to be here.
So in your book, you talk about the different roles of a lawyer as researcher, advocate, counselor. Could you speak a bit about the role of listening throughout those many different hats that lawyers wear?
It is part of the kind of ethos of being a lawyer that you say to yourself, oh, this reminds me of a case that I tried before. And a lot of times what you'll hear is that lawyers say, I find my career is that I'm trying the same case over and over again. And the trap of that, like a doctor, is that what you do is you may misdiagnose because you start to see patterns and things you've done before, and it makes you turn off your listening in order to be able to start to push the case into something that you know about, you're familiar with. I know in a clinic when I used to be involved as a clinician, we would have a person come in and we would ask different students what problems they saw in the interview that a person had presented to them. And the folks taking bankruptcy would see a bankruptcy problem. The family law people would see a family law problem. The litigators would see litigation opportunities. And so a whole lot of what is on somebody's mind can get in the way and block what it is that they're hearing from the client. And that notion of I am actually almost like a social science researcher trying to diagnose what the problem is can sometimes get bombarded with advocacy instincts that lawyers have. Ooh, I hope that this is the fact. I hope these are the facts because I both know something about that and I can fix that. Starts to color and compete with what a lawyer can do. Let me give you one example. It's really quite a strong one from the Delcon Shield days. One of the things that was really quite puzzling for Delcon Shield was as the Robbins company was trying to figure out how it is that the Delcon Shield could have gotten out on the market without them knowing or being more aware of the wicking problem, the infection wicking problem. And it turned out that the whole topic made everybody very nervous. That whenever you would ask folks about the research, often people would make a joke about it. Oh, maybe we should try, test it out on some of the women here. Yuck, 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 yuck. And the topic would get dropped. So that what you had is that the regulatory lawyers were not asking the questions about what kinds of testing had been done in order to be able to help them prepare about the regulatory search for the approval of the product.
What tips would you have for law students who are sort of forming their careers and having their first experiences asking questions and listening to answers that may be sensitive or uncomfortable or unpleasant? How can they develop their listening skills for those situations?
You know, I'd like to think about it in two ways. One is, there is a little sense where when you're interviewing a client, you want to send the message that I am there for you, I'm not being judgmental, I am trying to understand what it is that you're having to say to me. And I'm reminded of a wonderful Tennessee trial lawyer who says that he thinks his development of his practice was very much attributed to the notion that when a plaintiff would come in with a serious injury or with somebody in their family was seriously injured, he would say, thank you so much for coming here. He would say to his secretary, hold all my calls, cancel all my appointments for the rest of the day. I'm going to spend time with this person because I really need to know you, and I want to assure you I will do whatever I can. I'll look behind every rock. I'll look behind everything that I can because I want you to know that I am completely devoted to trying to make sure that you get what you are entitled to under the law in this case. So there's a part of it that's what you're saying when you're talking to a client, that I am completely with you. I'm not judgmental. At the same time, the lawyer needs to understand that, in fact, the client may come in an advocate role, trying to help persuade the lawyer of the need for that kind of representation, and so maybe what? Editing what they're telling them, and in fact, psychologically, maybe holding back, either because they want the lawyer to want to represent them, or maybe holding back because they're afraid of what it is that they know. And so I think young lawyers need to realize that while they want to present themselves as being completely empathetic and non-judgmental and a good listener, at the same time there needs to be a piece of them that is a little bit skeptical of what they're hearing. And that it's with that skepticism then that they can start to develop the listening skills to help them in nice ways make sure that what they're getting is the full story as opposed to just a partial story, and the bad facts as well as the good facts.
For experienced lawyers, you touched on this earlier, there's the idea that your pre-existing knowledge can shape what you want to hear in ways that maybe aren't great for really hearing the whole story. So I think everyone may have had that experience of having that problem, but what are some things that lawyers can do to actually overcome that?
I think in some ways we can learn from the medical profession here, because this problem of misdiagnosis is the ones that doctors face all the time. Their tendency is to start to see everybody as having the same flu. And so what they learn when they take a background, a personal history, is to be very careful up front to ask open-ended questions. How can I help you? Why are you visiting me today? What are you looking for? Really open-ended questions, all right? How are you feeling? Those kinds of open-ended questions. How can I help you? After an icebreaker in particular, where you spend a little bit of time saying, you know, what beautiful day it is, or how did you come to hear about us, or all those kinds of things that you do in a kind of a make friends and influence people, Dale Carnegie course kind of approach. You ask open-ended questions to make sure that you don't start to narrow too quickly. Tell me about it. And I like to think of it as in 3 stages. This first stage is open-ended, where you're trying to evoke a gush on the part of the client as the client tells you what it is that they're looking for. And let them frame it. Often they've prepared something and they're aware of the hourly rates that lawyers sometimes bill, and so they will come in often sometimes with a prepared spiel about that, and you can get out of the way and you can listen to that and let that occur if you don't start to become too active too early. And then the second stage for me is to try to put some structure in over what you're hearing, because often it does come out and there are flashbacks and flash forwards, and so what I like to do is to say that the second stage is, now I've got a sense of an overview of it, let's go back and let me take you through it. Sometimes we can get confused chronologically by what happened when. So how about if we go back, let's try to start at the beginning and march our way through this, and that way we can make sure that we're not getting confused as to when things occurred and how they occurred. So where do you see this as beginning? And the chronology is a way to impose a structure over the top of it. I think you should be free to take notes from time to time as you go along, make a timeline. Yes. And that what you need to do is you need to be careful that you consult that timeline in the silences, in the gaps, that you look at that and that you study that. You don't have to ask the next question immediately on, but that you use those notes then to get a chronology of what it is that you feel like has happened. And when you get a pretty good chronology, sometimes things don't line up with chronology. Sometimes they line up as topics. Tell me about your management. Tell me about how you marketed the product. And so sometimes what you're doing in a particular topic area is to arrange things by topics. But that sense of the organizational framework, which the client feeds into, helps you listen to the answers that you're getting. And it helps you to make sure you're not hearing things you want to hear as opposed to hearing things that are occurring in a particular way. Now the third thing is, by the way, is the most important one, and that is that at the end you go back and verify what you've heard. Yes. And the verification piece of it is the place that, for me, frees you up to be able to listen and then to say, okay, so let me see if I've got the basics out there. And that can be a way to free you up to listen, to pay attention, knowing that you're going to involve the client on the back end to ensure that you haven't heard something you want to hear as opposed to hearing something that actually happened.
And what would be an example of, part of good listening, I think, must be tone at this point in verification. So what would you say would be an example of maybe not an effective tone in verifying, and an example of a better way to actually do that verification stage and keep the rapport with the client?
Yeah, well, I mean, you know, of course, if you hear something that surprises you, it's really hard. Are you sure? That doesn't sound right. As opposed to a series of nonverbal cues that you can use first, and then verbal cues that you can use to try to verify the accuracy of the information that you have. For example, what you're doing with me is obviously very, very effective. It's very subtle. It's very nice. I feel like I'm being listened to. You're looking at me. Your eye contact is good. You're nodding as I'm talking. And that helps me become more articulate. It helps me start to do things. It makes it such that I don't have the time to edit. I now am feeding to an active listener who is trying to show me that you're listening, and you say from time to time, oh, excuse me, go on. Or you say, you just give me a little nonverbal, and that means I'm heard, go on. I see. All right. Sometimes what you'll say is you'll say something, oh, that's very helpful. And that encourages me to say more. Those are what I would think of as the usual nonverbal and verbal encouragements to keep people talking. And the more they talk, the more that they, oh, you know what, I got that wrong. Or you know what, I've got more to say, or I'm not so sure about it. So the extending the length of time somebody talks sometimes helps you with that. But then there is what I think of as the verbal cues, which come in the form of questions. Tell me more about that, with a little bit of puzzlement on your face. Tell me more about that. Help me understand that. Well, that's a little confusing. Help me understand that. Are what I think of as mid-level questions that do say, I think there's more of a story here. Before I say, no, that couldn't have happened, I want to make sure that I give you an opportunity to sort that out. And then, to my mind, two really important things that you can look for are, one, to restate what you've heard in your own words. So it sounds like to me that you feel like you were harmed, that you were wronged. Sounds like to me you feel like you did that intentionally. Sounds like to me you're scared about what happened. Now that last one is a feeling, scared. That's a little different. The psychologist would call that reflection as opposed to restatement. Restatement of just what they told you in your own words is enormously helpful as a probe. It says to the person, look, I'm paying attention to you, so it compliments them. And then it says that I get it right, and it gives them room to edit, to go back. You know, now that you restate it that way, I'm not sure I knew he was doing it intentionally. It may be that he actually was distracted, but it sure felt like he was doing it intentionally. And so what you have in the restatement is an opportunity for the person to tell you more and give you a correction. The reflection piece is a way of taking a little bit of the artificiality out of the interview. Instead of my playing a role of a lawyer, I'm now much more like a good friend who says, boy, you must have been really angry by that. Not, you have a right to be angry about that. But it sounds like to me you're still pretty upset about it, and or annoyed. And I can't say enough about a good psychological attention to various levels of emotion that are behind what somebody is telling you is a window to the soul. It's an opening to the person to start to talk to you in a real way, unedited, about what's going on. You bet I'm upset. I'm not sure I was angry. I would say I was annoyed. And in the refinement of the emotion, what you get is you get a clearer and clearer understanding of what's going on. And that, to me, is the benefit of active listening, the skills of using eye contact, head nod, the empathy, and then the use of questions, gentle questions, which pretty much say, tell me more about that. And then to the restatements, and then to the reflections that give you that kind of understanding about what happened, and it helps build rapport. It helps build the rapport that you need for the trust, for
Right.
the development of the relationship.
So a lot of times the clients do come in to vent. They need
Yep.
to be heard, like you say
Yeah.
in your book, and,
Yeah.
and we can all understand that. How does the lawyer handle the empathy aspect of it? Is it sort of put on your empathy hat and listen and sort of let them be heard, and then put on your informational hat and now start squeezing out information? Or can they be both in the same together in the same act of listening?
Now, when I think about my friend Bill Pryor from Tennessee, who would close the doors for the day in order to be able to take the time, in a sense, that's the ideal, that you can pay attention to somebody. And, in the business transactions area, everybody is concerned about the lawyer's time, and so what you have is you have an immediate suspicion that the lawyer wants to spend that kind of time with you in order to be able to jack up a bill, in order to be able to really make some money off of it. And so very often what you have is you have a natural tendency for the client to say, this may be costing me too much. So that disciplines clients very often to keep themselves on task. Now, some will vent. Some are there for the catharsis. Some know about the contingency fee aspect of it and know that there's no billable time that's going on with it. But I would have to say that generically, the concern that some lawyers have is, well, won't the client just go on and on and on and on, is not something that most experienced lawyers say is a problem. You usually get a gush. It usually goes about 10 minutes. Most people have a hard time continuing to talk longer than that. And then they need some structure.
Yes.
And that the lawyer can start to bring in the structures, and some of that structure can be the elements of a cause of action. Some of it can be the defenses that are available, whatever is going to be put onto it. But I think that the worry that if I'm too empathetic, I'll lose control of the witness right from the get-go, or the client from the get-go, and they will waste my time, is really not a major concern. It's not an early concern. Maybe a young lawyer might worry about that, but I can tell you that if you've got a CEO who is spending time with you, you will take whatever time you can get from
Yes,
them.
absolutely.
And you will be there, and you will spend that time until, in a sense, they say, I gotta go on, I gotta move on, or you'll make sure right at the get-go you'll be sympathetic to their time. I know you've got 45 minutes. Thank you very much for giving me that time. Maybe the best way we can start is you give me an overview of how you see things, and then I'll have some questions for you after that, and I would want to make sure and verify where we're at and what steps I'm going to take from there. So you'd put a structure over it. But my view is that you should err on the side of empathy and not worry about the cost efficiency. Stay in that empathetic mode, and then allow that critic, that skeptic, to be on your shoulder, to sit there and to be saying, I'm going to have to come back to that. Maybe there's somebody else I should talk to about that. And a lot of things you'll do at the end of an interview will be, hey, I'm going to need to talk to some people. I'm going to need to get access to some documents. I'm going to need to verify some things before I'm going to be able to tell you where we stand. And can you help me? Can you give me an opening to talk to these people and get access to these documents? And can I meet with somebody right now to be able to get that process started? And so you'll have that aspect of what you're going to do, which will help you get the skeptical side of things going. But I'd still say that at the beginning you want to be focused on the empathy.
Right. So you talked about control and sort of managing and showing that you have a purpose. And that area has been something I've heard over and over since starting the Listen Like a Lawyer project. Lawyers say, it's a mistake if you stick to your outline too much.
Right.
You need to be spontaneous,
Right.
but at the same time, you have to have a plan and have an agenda.
Right.
So at this fact investigation stage, what would be some of your suggestions for lawyers conducting fact investigation to have a purpose, have a structure, have a framework, but still leave room for spontaneity? It's like easy to say, but kind of hard to do.
Oh, it sure is. I think of it as juggling, being open at the same time having your eye on a ball, a theory that you're trying to develop. And of course, the preparation before the meeting is crucial. The notion that if you could get those documents, if you could get the pleadings before you sit down and have the first client interview, you'd be miles ahead. If you have a heads up as to what the topic is, and so you can go in with an idea of what some of the elements of the cause of actions that are possible are and what the possible defenses are, you're going to be miles ahead. But I always think of that wonderful movie, Anatomy of a Murder, and I think about the yin and yang of that. You remember that Ben Gazzara is the character who is accused of murder. He kills a man who rapes his wife, he says. And what you have is Jimmy Stewart, who's asking him some questions to try to figure out what his defenses are going to be. And Jimmy Stewart comes in the interview clip that is often the subject of this conversation, and he comes in and he says, look, let me tell you, you do not have a justification. So what's your excuse for killing Barney Quill? What's your excuse? And what he's doing there is to say, self-defense is not going to work because there was too much time. So don't tell me that you have a self-defense defense. You shot this guy, and you had too much time between the rape and when it occurred. So you better think about insanity and how crazy you are. Well, you know, that might have been true, but it could have been that within the event itself, there might have been a self-defense that could have possibly raised its head. And I always think about that movie as explaining to young lawyers how, yeah, he's probably on safe ground with that theory. But you know, if he says, I blacked out, I was insane, he misses as to whether there was a new self-defense opportunity, whether or not he pulled a gun, whether or not he did anything right before he shot him, which would have justified his use of self-defense. And of course, in our Trayvon Martin setting, we know how those things can start to become very, very fluid, and you can miss a defense. So the more the lawyer feels like they already know what happened, the more danger they run, because they may be guiding the person into a particular defense that is not defensible or is not the best defense that's available, if that makes sense.
It does. It's interesting that you say that, because the idea of a blog post about that very movie has crossed my mind, so I think you just checked that one off the box. Thank you. So let's talk now a little bit about the lawyer as a listener in terms of professional development. How can a lawyer, you know, starting out, work on his or her listening skills, and how do you see that sort of evolving over time as someone becomes more experienced and expert in what they're doing?
You know, you'd hate to say that practice is the absolute key, but in some ways, part of the reason why it's so hard for us to pay attention to listening is because we feel like we're already very good at it. We've done it all our lives. That's what we do. We listen to friends. And I think part of it is to start to put yourself into a role when you're dealing with a client that is less professional and more as it would be with a friend. That the sooner you can start to see that person as that you're developing a friendship that's going to require sometimes tough love. It'll get you in the state of mind, I think, that is necessary for you to be able to listen to them, to care about them, and to be able to make sure that they have complete information so they choose the right way. It's real easy for you to blame the client. Well, I got bad clients. I've got stupid clients. I've got clients that don't tell me the full story. But you know, part of that is whether or not they've gotten a read from you that they can trust you. And of course, you can do some things with confidentiality promises that can help that. But otherwise, it's an attitude toward them, that you actually care about them, that you're there for them, that you're paying attention to them, that you, if you don't have that genuinely, you've got to figure out a way to fake it, because if you don't have that, it's going to be very hard for you to get good information and clear information. After that, I do think there's some techniques. I think that the techniques can be something you can practice. The notion that from time to time, when you're hearing new information or hard information or things that are new to you or things that are challenging to you, that you learn to quiet yourself down. And I can say to young lawyers, the best question often is no question. It's just using silence to say, I don't know what to do with this. So if you stay silent, the person will often give you more. And it's in the giving you more that you start to figure out what you need to do. And it's in the getting of more that often is the key to what your options are going to be as you move into a counseling mode. And so what you want to do is to say to the person continually, tell me more about that. How do you see it? What options do you see as to how you might react to this? And that putting it back on the person to tell you more about the complexity, more about the feelings, is a really, I think, an important skill. And I'd say it's a default skill that you'll see very experienced lawyers use in a variety of settings where, frankly, it takes the pressure off. Instead of having to be an answer person and having to answer it and answer it quickly, what they can do is, frankly, buy time by asking the person to tell you more. Or to say, you know what, I think we've got a good start here. I'm going to need to think about this. Maybe what would be helpful is if you would go home and write up a chronology of the events and to, frankly, buy some time to get yourself up to speed is also not a bad place to start before you feel like you've developed an expertise that you're able to see what the next steps are going to be. And I always say the difference between a young lawyer and an old lawyer is that the old lawyer knows there's no right answer, knows that in fact there are multiple answers that will have to be sorted out, whereas the young lawyer thinks that there's a right answer that will fix this problem, and that sometimes creates pressures on the young lawyer to stop listening and start to be self-concerned about what they're going to do, and especially in the fact investigation stage, if what they can do is they can stay open. They're going to figure it out. They're smart folks.
I think back to my own time practicing law, and I think maybe when I started out, sometimes I was a frantic listener,
Yeah.
whereas the experts are going to be more of a relaxed listener, just for the reasons that you
Me
stated.
too. I'll never forget. First interview of my life as a young lawyer. Person comes in was trying to figure out whether or not they wanted to file for bankruptcy. I had a creditor's rights and bankruptcy class. It was some period of time ago. I didn't know off the top of my head between chapter 7 and chapter 13. I barely knew that he was coming to see me for a bankruptcy, so I had very little notice about it, and I'll just never forget how I remember my hand was shaking as I was taking notes. I just had no idea. But anyway, those are those beginning fears that you realize are going to be important to manage as you try to get past all that uncertainty about what you know. Yeah. Good.
Paul, thank you so much for your time. I really appreciate it. Thank you for your thoughts. And thank you.